Good evening. Welcome. My name's Josie, and I'm going to be talking about special education law. To get right into it, I'm going to give a brief history of special education before the 1970s, and then the 1970s, and then present level. So, to get right into it, in 1893, the Massachusetts Supreme Judicial Court ruled that children who were, as they described, weak-minded were unable to benefit from instruction. They also contested that children with disabilities were troublesome to the rest of the classroom, and they made unusual noises. This being said, they were for the fact that if a child with these discrepancies could not physically take care of themselves as the other same-age children could, then they should not be allowed in public education, as their families were advised to find alternative placements such as a day treatment school designated for the deaf. From just this one instance, it is crystal clear that special education before the 1970s was not even noted to be identified nor labeled as special education. In other words, it merely ceased to exist. During the 1970s, however, a few years ahead, judicial decisions brought light to special education and the right to receive these educational services, specifically through the court case Mills versus Board of Education. This was in 1972. These rights were sought to be capable under the 14th Amendment of the Constitution. After this occurred, more improvements took flight, with improvements to laws including the Education of the Handicapped Act of 1970, where later on the term disability was substituted for the word handicapped, which realistically improves the societal perspective of special education altogether. Present day, special education is rapidly improving with ever-growing technological advancements in the encouragement that students on an IEP are continuously improving and advancing in their skills while being closely monitored through individualized assessments and progress monitoring strategies. So, in other words, before the 1970s, special education was, as I said, merely non-descriptive. It didn't adhere to special education policies, laws, whatever we have now. It didn't exist. And students with disabilities at that time were treated practically like they didn't matter. So I'm glad that we have made these advancements in history and present day level education, because without that, we'd be lost. So as we continue, I would like to touch on a couple of court cases that involved parental rights and students' educational rights, such as FAPE, so the free education for all peoples, and IDEA. So the first court case that I will briefly address is actually one of the most recent ones, especially one that actually hits home for me because I did work in Douglas County School District, which is in Colorado. So basically, for time sense, the case is Andrew F. versus Douglas County School District. So Andrew is a student with autism and with a medical diagnosis of ADHD who attended public school from kindergarten to fourth grade. But Andrew's parents noticed little to absolutely no progress in his time in public education. His modifications and accommodations were not being carried out with fidelity, where his parents withdrew him and put him in a private school that emphasized on teaching students with autism. The decision in this ruling was that the district would pay for his private school tuition, as the parents immediately saw a difference with an advancement in his academic well-being. The Supreme Court sided with the family, as free appropriate education was basically slipping through the cracks. Appropriate would coincide with adequate, and since Andrew's progress was merely vacant, the school district lost their battle. Although this eye-opening case may constitute for better training, ideally, for the future. Additionally, many years before this, we had PARC, P-A-R-C. It happened, which PARC, P-A-R-C, stands for Pennsylvania Association of Retarded Citizens. Honestly, personally, I'm glad that word ceases to exist any longer. But in 1972, PARC versus Commonwealth of Pennsylvania ended in a victory to allow special education students their freedoms to receive FAPE without segregation, meaning that before this, the students were allowed to have their free public education, but they were put into self-contained environments where their teachers were lacking training and they weren't getting appropriate education, as FAPE stands for, right? So the case was effective because parents fighting through the advocacy, advocate groups for disabilities, it helped. Regardless of the time, when, and where, each of these cases and many others led to what we call Individuals with Disabilities Education Act. And before I go, I have 3 to 4 recommended resources. I have about 3, but one that I recommend the most is I personally work for Laramie County School District 1, and we have a special education handbook that actually was published within this year. There's also the U.S. Department of Education's website, where this offers parents their own resources, whether it be for IEPs, frequently asked questions, assistant networks, or general resources for school and home. It's worth a look. The link that you can use or access this is www.ed.gov/parents/landing. And last but not least, LDA, Learning Disabilities Association of America, offers adequate support for parents with children who have disabilities or those whom are needing guidance in how to get a diagnosis, etc. Well, I hope this presentation found you in a supportive place. Thanks for watching.